Did you want to argue?
We've laid out in our opposition, Your Honor, there's no basis. We've used 131 witnesses, 48 of whom have been related to law enforcement. The defendant has made no showing in his motion that anything that Trooper Benson would have said was nothing more than cumulative or corroborative, and therefore there's no basis for the court to allow the motion.
The court declines in the exercise of its discretion to give the third supplemental request for jury instruction, find that the Commonwealth has proffered an adequate explanation for not calling the witness, that in its memo and in footnote 1, that in addition, some of the matters about which the defendant would have liked to have questioned Lieutenant Bennett about, dealing with specifically the items in F, G, and H of their request, deal with witnesses who did not testify in this case, and the potential witness here is not an eyewitness, and a witness may be withheld where he is susceptible to cross-examination on collateral issues. That is certain; those are collateral issues. The decision as to, and in addition, the decision as to how much time the Commonwealth wishes to spend in countering inferences that the defense seeks to draw is a strategic judgment looking at all of the circumstances and facts of this case. I find that this is not a case in which the court will give the missing witness instruction.
Your Honor, I certainly understand and respect the court's ruling. I just want to make sure before argument that that in accordance with the language of the SJC's decision in Salentino, that the defendant may, says, quote, the defendant may even legitimately point out that a specific witness or a specific witness has not been produced.
Right. What you can't do is ask for the inference. For them to draw an inference, you can use your Bowdoin, ask the inferences to be drawn from whatever your Bowdoin argument is. But in terms of that evidence was not produced,
I can point out that a specific witness
point out that evidence was not produced. Did you wish to argue at all on the motion for required finding?
No, Your Honor, we'll waive argument.
Thank you. I assume the Commonwealth does not wish to argue the motion for required finding.
Nothing further than what we previously said.
The motion for required finding of not guilty is denied. I find that the Commonwealth's case has not so weakened during the defense, and that a rational finder of fact could find the essential elements of each of the indictments charged and therefore deny the required motion for required finding.
Your Honor, I just have two questions, logistical questions. Number one, are the jurors going to be permitted to take notes during the closings? They will. Okay.
But I remind them that absolutely nothing the attorneys say in the closings is...
And secondly, I said the two closings will be back-to-back?
Yes, I'm not going to interrupt between the two closings, but after the closings, I will either take a short recess and then go to the charge, or depending on what time it is, take a early lunch recess, and we can make that decision then. I did want to say a few things about closings, reminders. Reminder that counsel may refer only to facts that are in evidence, and counsel should not comment on the defendant's decision not to contradict a testimony or not to introduce evidence. Counsel may not express a personal belief in the credibility of any witness or the rightness of their case or justice of their case. Counsel must avoid words like "I believe," "I think," "it's my opinion." Counsel may not vouch for a witness by suggesting or implying that counsel has knowledge independent of the evidence that supports the credibility of the witness. Counsel may not appeal to the sympathy, prejudice, or passions of the jurors, may not ask members of the jury to put themselves or any one of their relatives in the shoes of the decedent or in the shoes of the defendant. Evidence admitted for a limited purpose may not be used for any other purpose, and care should be taken not to misstate the purposes for which evidence may be used by the jury. No comment directly or indirectly or by implication on the defendant's failure to take the stand or on any pretrial silence. No references to the consequences of the verdict or to the impact of the verdict on society, the decedent's family, or the defendant's family. I believe the court officer announced at some point that during the court's charge, if anyone leaves the courtroom, they won't be permitted back in order to, so that it won't be disruptive. There will be an opportunity before the charge, if anyone wants to leave at that time. Any objection to that public access during the charge? Counsel?
No objection by the Commonwealth, Your Honor.
I'm sorry, Your Honor. I'm sorry, I missed that question.
That during the charge, as is typical, persons will not be allowed in. Anyone in who leaves will not be allowed back in. Any objection to that? Thank you. And we can bring the jurors in.
Be heard. God save the Commonwealth of Massachusetts. Court is in session. Be seated, please.
Yes, please.
This is Tuesday, April 7, 2015. Returning to Commonwealth versus Aaron Hernandez, indictment 2013-983.
Good morning, ladies and gentlemen.
Good morning.
Have any of you seen or heard or read or overheard anything at all about this case or Mr. Hernandez since our last inquiry? There are no affirmative responses. Have any of you discussed this case or Mr. Hernandez with anyone at all since our last inquiry? There are no affirmative responses. Have any of you had any difficulty following my instructions not to talk about or in any fashion communicate about, look at, listen to, or do any research concerning this case, anything you think could be relevant to the case or Mr. Hernandez? There are no affirmative responses. You are about to hear closing arguments by the attorneys. This is their final opportunity to address you. It is their opportunity to summarize the evidence or to call your attention to certain parts of the evidence, and based on the evidence to try to persuade you to reach a certain result. However, what you're about to hear is not evidence. The lawyers are not witnesses. They do not know what happened. and they are not testifying. Nothing, they say, is evidence. Our rules are designed to ensure that the parties receive a fair trial. Therefore, obviously, the attorneys cannot refer to facts that are not in evidence. If based on your memory and understanding of the evidence, a lawyer does this, disregard that comment. The lawyers are also not allowed, under our rules, to express their own personal belief or opinion into the credibility or lack of credibility of any witness who testified in the case. That determination is entirely for you to make. If a lawyer makes such a comment, please disregard it. The case must be decided solely on the basis of the admissible evidence and the law that I give to you. Attorneys are not permitted to attempt to persuade you for or against either party by appealing to human passions or prejudice. If a lawyer makes such a comment, disregard it. The prosecutor will go last because the Commonwealth has the burden of proof. It's allowed to have the last word. You may.
Good morning, everyone. It's been a long trial. We started back in January. Slogged through those mountains of snow, and now it's spring. Each and every one of you have made personal sacrifices to serve on this jury, to perform one of the most important and most difficult jobs that any citizen can perform, to sit in judgment of a fellow citizen charged with murder. And in addition to being here early each and every day, I've noticed, we've all noticed, the incredibly careful attention that you've paid throughout the case. Even when it got a little slow at times, your attention never wavered. You were all on the evidence. For your time, for your attention, for your hard work, I thank you. My colleagues, Mr. Fee and Mr. Rankin, thank you. And our client, Aaron Hernandez, thanks you. Now, there have been a lot of spectators at this trial. A lot of cameras. A lot of media attention. None of that matters. Not one bit. Because you, the jury, are going to decide this case. No one else. In our system of justice, it's you, the jury, that stands between the government as the accuser and the individual citizen as the accused. It's up to you, the jury, to decide whether the prosecution has proven its case beyond a reasonable doubt. And if that heavy burden has not been met, then, under our American system of justice, there is only one possible, one lawful verdict: not guilty. Now, most of you took notes during the trial, and I'm going to use some notes during this closing because I want to make sure that I don't forget anything that I need to say to you. So I hope that you won't hold that against me if I refer to notes from time to time. Now, the police and prosecutors have tremendous power. And with that power comes responsibility. The responsibility to conduct a complete
and a fair investigation of all the evidence, to be objective, to look at all the evidence first, and then see where they end up. Not to start with a conclusion, and then look for evidence that fits that conclusion. You, the jury, are ultimately going to decide whether the prosecution has fulfilled its responsibility, in this case, to carry out a fair and objective, a complete investigation in bringing you the evidence it brought you for the past 9 years. Now, let me suggest first a couple of things that you should not consider in jury deliberations, in rendering a verdict. First is everything that has been said and written in television, radio, the internet, out in the public about Aaron Hernandez since June of 2013. Let's not kid ourselves. There's been plenty of stuff out there about Aaron and about this case. And let's not kid ourselves, all of you have been exposed to it. You candidly told us that back in January during the jury selection process. All of you. But you told us something else. You told us you could be unbiased. You told us you hadn't prejudged the case. You told us you could put aside whatever you had heard or read or seen and be fair. And we believed you. And that's why you're here. You've all paid careful attention every day to Judge Garsh's inquiries about whether you've seen anything, Judge Garsh's instructions. Not to be influenced, not to be exposed to outside information, to any information that wasn't presented to you in this courtroom. Why is it so important? Why is it so important not to make a decision based on outside information? All that outside information out there. Why is that so important? Well, because if that's what you do, if you decide this case based on information that's come to you from outside the courtroom at any time, we've all really been wasting our time for the last 3 months, haven't we? Why have a trial at all if somebody can be tried, and for that matter convicted, in the media? What's the point? We may as well just close down this courthouse and every other courthouse in America. Put a sign on the door, out of business. And while we're at it, we may as well flush our Constitution down the drain. Please don't do that. I ask you, if anybody brings up any outside information during the deliberations, and I hope and expect that it's not going to happen, but if anybody does that, please speak up. Please don't let that infect, taint, contaminate your solemn deliberations process in this case and the return of a fair and impartial verdict. The material on the outside, media, people in the community, gossip, none of that material has been challenged. None of that material has been scrutinized. None of that material fits the rules of evidence. It's simply unreliable. You have to decide this case based on the evidence presented to you in this courtroom and Her Honor Judge Garsh's instructions. And I know you'll do that. Now, let me mention a second thing that I'd ask you not to rely on in deciding this case. And it may seem strange to hear it coming from a lawyer, but it's what lawyers tell you. It's what lawyers tell you about what happened. It's what lawyers tell you about what the evidence means. That's your decision. That's what you're here for. So if a lawyer, any lawyer, gets up here and acts out what the lawyer says happened, tries to tell you what's in a video, tries to tell you what a piece of evidence means, make up your own minds. That's your job. That's your job. So how do you go about analyzing the evidence in this case? How do you do your job? There's plenty of evidence. You heard from more than 130 witnesses. There are more than 430 exhibits, some of them really voluminous. I submit to you there are really two ways you can go about analyzing the evidence. The right way and the wrong way. The right way is to start with the presumption of innocence. Look at all of the evidence fairly, objectively, without judgment. Look at it all and come to a conclusion as to whether or not the prosecution has proven its case beyond a reasonable doubt in accordance with Judge Marshall's instructions, in accordance with our Constitution, in accordance with 200 years, more than 200 years of American history. That's the right way. So what's the wrong way? Well, the wrong way is to start with the presumption of guilt. Assume that Aaron Hernandez is guilty when you start, and then look for evidence that fits that presumption of guilt and disregard everything else. That, I submit, is what the prosecution did in this case, what the police did in this case. But that's not what you should do during your deliberations. That's the wrong way. And there's another wrong way, too. A wrong way which the prosecution's presentation during the last 9 weeks has really invited you to go down. And that's to look at the case as kind of a mystery for you to solve, kind of like a whodunit. Pick a theory and go with it. Try to find evidence that supports that theory. And see which theory you like best. Fill in the gaps in the case with guesswork, speculation. Use your imagination. It's like a mystery. Not in a court of law. This isn't a mystery show. The question is whether the Commonwealth has proven its case beyond a reasonable doubt. And that's the only question that you should be addressing during your deliberations. I submit that if you look at the evidence the right way, with a presumption of innocence, starting there and being objective and looking at everything, you will have to conclude that Aaron Hernandez is not guilty of murdering Odin Lloyd. The only way you can get to a different conclusion is by analyzing the evidence the wrong way, by starting with the presumption of guilt, or by picking a theory, filling in the gaps with guesswork, speculation, and imagination, and picking the theory you like the best. really two overriding questions in this case, factual questions. Who killed Odin Lloyd, and why did it happen? The prosecution chose to point the finger at Aaron Hernandez. Have they proven that Aaron Hernandez murdered Odin Lloyd? Have they explained why? Let's start with the evidence, the undisputed evidence about the relationship between Aaron and Odin. Odin met Aaron in the summer of 2012 through his girlfriend, Shania. Many, many weekends, Shania and Odin would spend the weekend with Aaron and his fiancée, Cheyenne. When they were together, Odin and Aaron would frequently go off together, spend time together, hang out together, smoke marijuana together. Shania told you that. Cheyenne told you that. Nobody told you anything different. Isaiah Jenkins, Shania's uncle, said that Aaron, from his observations, when he was there, Aaron and Odin seemed close. Sometimes they would go out, the four of them would go out to spend time together. But at all of these events, Aaron and Odin would be together. Aaron and Odin. Aaron and Odin shared a passion for marijuana. Odin was very skilled at rolling blunts. Odin would roll blunts for Aaron, and they'd smoke together. It's an activity they shared. On the first weekend of June 2013, Aaron and Odin were together at Club Rumor in Boston, where they went for Cheyenne's birthday party. In that party bus you saw photographs from. The following weekend, Aaron and Odin were together at a club in Providence. And on Friday night, June 14th, a night you've heard a lot about, Aaron and Odin again went to Club Rumor in Boston. Were they friends? Obviously they were friends. They were future brothers-in-law. But the prosecution wants to deny the obvious. The prosecution has presented through its evidence a number of possible theories of why Aaron would want to murder Odin. Let's go through those and see if they make any sense. Alexander Bradley testified last week, as I recall. He told you that in December or January that he was in the kitchen of Aaron's house with Aaron, and Shania and Odin walked into the house, walked in through the kitchen, and went upstairs and didn't say hi. And Aaron remarked to Bradley that that was rude. Does the prosecution seriously expect you to believe that Aaron spent the next 6 months plotting to murder Odin Lloyd because he didn't say hi? That's theory number one. Theory number two. Remember Kwame Nicholas from Rumor? He said that he was in Rumor on Friday night June 14th, and he saw Aaron staring at Odin. And that when Aaron left the club, he looked angry. Well, nobody else saw that. Kwame said that it was when Odin was speaking to Glenroy Herbert that Aaron was staring. They didn't even call Glenroy Herbert as a witness. You saw the video of Aaron inside the club. Aaron outside the club. Was he staring? Was he angry? And remember Kwame Nichols on cross-examination when he was shown, when he denied what was in his own videotaped interviews? Does the prosecution seriously expect you to believe that Aaron orchestrated a plan to murder Odin based on that testimony? What's the third theory that could be taken from the evidence? Well, maybe Aaron was worried that Odin would tell Shania that Aaron and Odin spent that Friday night into Saturday morning with Jennifer Fortier and Amanda DeVito. Maybe Aaron didn't want that to happen. Well, what do we know about that? Saturday morning, June 15th, Aaron texts Cheyenne. Tells her all about the fact that he's with Odin, that they're at his other spot. He apologizes. And he sends that text on Odin's phone. Is that text, which we'll look at in a few minutes, supposed to be some coded message about how Aaron was really upset with Odin? I'll show it to you later. I'll read it to you. It's too small. Here's the message from Aaron to Cheyenne on Odin's phone, Saturday morning. Excuse my language. I fucked up again, and I didn't mean to, but got drunk and too fucked up, and O took care of me, and somehow told him about my other spot, and I just woke up bugging, I'm sorry, and on way home. On Odin's phone. Does this reveal any concern about Odin? And what about infidelity? Is Aaron worried that Cheyenne is going to find out that he was out chasing after other women? What did Cheyenne tell you? She told you she knew all about Aaron's interest in chasing other women. She didn't like it, and she hoped he'd outgrow it. But it wasn't anything secret from her. It wasn't something she didn't know about. Does the prosecution seriously expect you to believe that Aaron orchestrated a plan to murder Odin because of this? Well, what are the other possibilities? Well, there was evidence about Odin supplying Aaron with marijuana blunts. Well, maybe there was some big fight over marijuana. Maybe there was some marijuana deal gone bad. Is there any evidence of that? Is there any evidence of any conflict of any kind between Aaron and Odin? No. And remember the testimony of, I don't remember his name, but the person who was in the photograph holding up the two baggies of blunts, he said it was worth about $600 total. That's less, I submit, or you can infer that Robert Paradise to go to California. Does the prosecution seriously expect you to believe based on the evidence presented, that Aaron orchestrated some plan to murder Odin over some imaginary drug deal gone bad? There's no evidence of it. No evidence at all. If there was evidence of any reason that Aaron had to murder Odin Lloyd, don't you think you would have heard about it in 9 weeks? But you didn't hear it. You didn't hear it because it doesn't exist. Does the prosecution expect you to fill in that gaping hole in its case with guesswork, with speculation, by using your imagination? Is that proof beyond a reasonable doubt? Now, what are some of the other things you're being asked to speculate about in this trial? Remember all that stuff about Florida? There was evidence that Aaron sent $15,000 to a fellow named Oscar Hernandez in Florida in April of 2013. But there was never any evidence about what that money was for, or any evidence linking it in any way to the murder of Odin Lloyd. There was evidence about a car that was transported from Florida to Massachusetts, and Oscar Hernandez's name was on the shipping documents, and a boarding pass in the name of Wallace. Ernest Wallace was in a duffel bag inside that car. Was that connected in any way to the murder of Odin Lloyd? Was there any evidence of that? Or are you just supposed to figure it out, guess, speculate? And what about that .22 that was in the woods? Any evidence that that was connected to the murder of Odin Lloyd? Or are you again being asked to fill in the blanks, fill in the gaps, speculate, figure it out? That's not proof beyond a reasonable doubt. And something else that the prosecution has done in this case, they've taken completely benign, innocuous events and tried to cast them in a sinister light. Think of all that evidence about rumor on Friday night. Aaron didn't thank the VIP host for a drink. Aaron ducked down so some fan couldn't take a photograph of him. Remember the woman who said that Aaron got aggressive when they were dancing? And they just tried to look like a bad person? And as it turned out, she asked him to dance. And you saw the video. Was he being aggressive in that video? You're supposed to take that evidence and somehow use that to suggest that Aaron Hernandez murdered Odin Lloyd? Where does that leap come from? Now, let me talk some about the investigation that resulted in the evidence that was presented before you. I'll ask you to rely on it, convicting Aaron of murder. Let me show you an exhibit. This is a scene in front of Aaron's house on June 18, 2013, less than 24 hours after Odin Lloyd's body was discovered. someone in law enforcement had obviously leaked the fact that Aaron Hernandez was subject to this investigation to the media. They fixated on Aaron right away, right from the start. And that's really where this whole investigation went wrong. Let me show you another example. This one. There's a saying that a picture is worth 1,000 words. This picture tells you everything you need to know about the investigation that was conducted in this case. This is a shell casing attached to a wad of chewed bubble gum. They were attached when the police found them inside a dumpster at Enterprise Rental Car on June 20, 2013. You will recall that a whole bunch of people rushed to Enterprise that evening. Not just any ordinary police officers, the chief of police of North Attleboro, supervisors, even the prosecutors themselves. They didn't wait for crime scene services to arrive. No, Sergeant Baker jumped into the dumpster and started emptying all of his contents into the back of his pickup truck. Kind of incredible, really, but it got worse. Remember that as each of these officers testified, none of them wanted to admit to being in charge. None of them wanted to say who made the decisions. Finally, Trooper Mackin, to his credit, acknowledged that he decided on his own to separate the bubble gum from the casing, something he failed to document in any way. So the casing was turned over to the crime lab for DNA analysis without the gum. Even more incredibly, their own DNA analyst, Diane Fife-Biagiotti, she wasn't told that the casing had been attached to a wad of chewed bubblegum before she did her testing. Do you recall how her facial expression changed when I showed her that picture? While she was on the stand? She suddenly realized what the police had done to her. By keeping this critical information from her, they had set her up bad. They had snookered her. Just like at trial, and we'll get to it in a minute, they tried to snooker you. You heard what she said. She said it was important to know that the shell casing was attached to the bubble gum. She said she'd like to know whose DNA was on that bubble gum when she tested the casing. She said there was a high likelihood of transfer from the bubble gum to the casing. In other words, the casing was contaminated, rendering the DNA results on that casing meaningless. And they didn't just try to keep that information from her, they tried to keep it from you. You recall that during his opening, the prosecutor made a big deal of how Aaron Hernandez's DNA was found on a shell casing. It was the centerpiece of their forensic case. What he didn't tell you was that that casing had been attached to a piece of chewed bubble gum. We had to tell you that. And incredibly, the prosecution never even bothered to test the bubble gum. Why? Why wouldn't they test it? Why wouldn't they test it? Because it didn't fit their presumption of guilt. We had to test it earlier this year and call our own witnesses to present you with the results. You recall that yesterday when Jennifer Smith, the analyst from Sunmark that we called, testified, they barely even cross-examined her. Why was that? Was that because she did what they should have done? What they failed to do? This photograph tells you far more eloquently than I could about the bias, the manipulation, the incompleteness of the prosecution's investigation. The investigation they've relied on in this courtroom to try to convict someone of murder. They would do whatever it took to accomplish their goal. That's not science. That's scary. And it's not proof beyond a reasonable doubt. You know, we all rely on science as part of our lives. When we go to the doctor, we rely on the blood test, the needle's going to be clean, the tube's going to be clean, the people who do the testing are going to be trained properly, so we can rely on the results. Unfortunately, in this investigation, the state troopers who conducted these tests did not meet those basic standards. So their conclusions cannot be relied on by you beyond a reasonable doubt. These people were presented to you as experts. What kind of training did they have? Trooper Gerard, the tire guy, he told you on direct examination he had taken 2 one-week courses. Well, on cross-examination, it turned out he had taken 1 course and it was less than a week. Sergeant Mackin told you on direct examination he was a certified fingerprint examiner. On cross-examination, not so much. And what about Lieutenant Bennett? Remember Lieutenant Bennett, the person who analyzed and then later reanalyzed the footwear impression? The prosecution made so much of during this trial. It turned out he wasn't certified either. He had taken a single 3-hour course in footwear impression analysis back in 2006. Let me show you another exhibit. Here's the scene on the night of June 17, 2013. Most of it is uncovered. You heard about the chaos as dozens of officers arrived and basically milled around and did their own thing. There were lots of footprints, but only 2 were properly photographed. What evidence was lost? No measurements were taken. Some evidence was collected, some evidence wasn't collected. What about this item? A white towel lying on the ground near the body. How far? How near to the body? Nobody knows. Nobody bothered to measure. Any footprints nearby? Who knows? There may have been a passing thunderstorm, but that's no excuse. In a murder case, that's no excuse. Apart from sheer ineptness, the investigation was infected with bias. The police and prosecutors decided at the beginning that Aaron was guilty, and they sought to come up with evidence to support their conclusion. Trooper Mackin candidly admitted the goal was to convict Aaron Hernandez. So certain testing wasn't done at all. They never even bothered to get Ernest Wallace's DNA. They never tested human hair found on that towel for mitochondrial DNA. And they never tested the blue bubble gum. Why not? They knew Aaron had bought blue bubble gum. He had offered it to Kelia Smith, an enterprise. They knew it was likely that Aaron's DNA was going to be on that chewed bubble gum attached to the shell casing, which would render the DNA results on that casing meaningless. So they just didn't test it and hoped that no one would notice. But someone did notice. And as for the testing that was done, it was utterly infected with confirmation bias. That's a fancy term. What does it mean? We asked a number of prosecution witnesses about it, and they told you. Where information is incomplete or ambiguous, people tend to see what they hope and expect to see, whether or not it's really there. That's human nature. And forensic examiners are not immune from that. And that's a particular problem in this case, where the examiners were not kept separate and independent from the rest of the investigation. You heard the soil analyst from the FBI who came in. She said, that's the right way to do it. Keep the forensic people separate, independent, objective. But that's not how they did it here. Instead, the forensic examiners provided all kinds of information, outside information about the investigation. They knew exactly what the prosecutors were looking for to try to convict Aaron. And consciously or subconsciously, that's what they tried to deliver. They were trying to help. That's not objective. That's not fair. That's not science. Perhaps the best example of how bias contaminated the prosecution's investigation was the footwear impression evidence. What happened with the analysis of that partial footwear impression at placard number 2? I'm sure you remember it, but let me review it. On March 18th, 2014, Lieutenant Bennett examined the photographs of that impression. He concluded that there were insufficient detail present in that impression to conduct any further comparisons. So he did nothing further. Nothing more on that front. For months and months and months. That would appear to be the end of the story for this evidence, right? But wait. On November 20th, Lieutenant Bennett got a visit from the lead investigator, Trooper Eric Benson, and they had a private chat. Trooper Benson, who's not a footwear examiner, told Lieutenant Bennett that in Trooper Benson's opinion, the outsole on that impression at placard number 2 was consistent with the outsole on type of shoes that Benson believed Aaron Hernandez was wearing that night. Benson told Bennett to go back and take another look. So Benson went back and took another look. And when he did, on November 25th, lo and behold, the very same photograph that back in March lacked sufficient detail to make a comparison, now the same photograph had sufficient detail. And he made a comparison. And he agreed with Benson that the outsole on that impression was consistent with the Nike Retro shoes that he was given. Now, all that Bennett was willing to say, even after talking to Benson, was, well, that's a class similarity, and that it could have been made by a Nike Retro. And you heard the fellow from Nike say there are more than 3 million of those particular outsoles that have been sold prior to June of 2013, and there are tens of millions of other outsoles that have herringbone patterns. So, whatever the prosecutor may say to you in his closing, there was not a match made between that partial footwear impression and a pair of Nike Retros. But there's no doubt, Bennett's opinion changed. And it changed for the better as far as the prosecution was concerned after his chat with the lead investigator. So what's wrong with this picture? Well, what's wrong with it is that it's the opposite of a fair and unbiased investigation. Once forensic examiners are influenced and pressured to change their opinions aren't worth anything. That's what happened here. And what about Trooper Benson? You've heard his name a number of times during the trial, the lead investigator, the one telling others what to do. Do the prosecutors ever put him on the witness stand and subject him to cross-examination to defend the investigation, its fairness, its completeness? Why not? Ask yourselves that question. In sum, the investigation done in this case was incomplete, biased, and inept. That was not fair to Odin Lloyd. That was not fair to Aaron Hernandez. And it was not fair to you, because it left you with a whole bunch of unanswered questions and not enough proof. But that's all you've got to work with. Think about the incredible resources that have been devoted to this case by the prosecution. Don't you think with all the time and money and resources devoted to this case that they would have come up with a lot more evidence than this if Aaron Hernandez were actually guilty of the crime charge? But they didn't. All that effort, and this is all they could come up with. What does that tell you? It tells you that unless you start with a presumption of guilt, you can't get to where they want to get. They started with the presumption of guilt, and they desperately tried, but failed to find evidence. Now, let me talk about two people you heard remarkably little about. Excuse me, during the course of the trial. Ernest Wallace and Carlos Ortiz. According to the prosecution, they were two of the three people who picked up Odin Lloyd on Faison Street around 2:30 in the morning on June 17, 2013, and drove with him to North Attleboro. Doesn't that make them important? So what do we know about them? This is Ernest Wallace from Bristol, Connecticut, also known as Bo or Fish or Crash. He lived wherever he could, here and there. He was a friend of Aaron's. Sometimes he stayed in the basement bedroom at Aaron's home. Sometimes he stayed in Franklin. Sometimes he stayed at the Singleton home in Bristol. Now, the prosecution will try to make much of text messages that Aaron sent to Wallace on Sunday, June 16th, urging him to return to Massachusetts. That's part of their theory that this was a planned, orchestrated murder. Does that make any sense? Let's look at those texts. Here's what Aaron texted to Wallace, 2:14, I think, in the afternoon on Sunday. I'll read it. All y'all trying to step tonight. My girl's getting on my nerves. Hey, just don't be too late, my nigga, please, cause ain't trying to be stuck with her all day and night. Well, a very nice thing to say about your fiancée, but does this sound like somebody who's orchestrating a murder plot? Aaron wants to go out. He likes to go out. He likes to drink. He likes to smoke marijuana. He likes to chase women. He wants to go out. Does that mean he's orchestrating a murder? And then later on, another one. "9:02. This is when they're at South Street Cafe in Providence. Please make it back, because I'm just trying to step for a little. Sound like somebody who's orchestrating a murder plot? There was nothing unusual about Aaron and Wallace exchanging text messages or phone calls. They were friends. They joked around with each other. In fact, if you review Aaron's phone records that are in evidence, you'll see there are more than 900 contacts, calls or texts between Aaron and Wallace during the first half of 2013. There was nothing special about their communication that particular weekend, unless you want to take something that's completely innocuous and benign and look at it in a sinister way. Oh, he's summoning him back. He's summoning his Confederates to carry out the orchestrated murder plan. Where is the evidence of that? That's a story. That's made up. That's fiction. That's not proof, let alone proof beyond a reasonable doubt. Well, what else do we know about Ernest Wallace? We know he was a drug dealer. And we know he used PCP, or angel dust. We know that he sometimes acted aggressively or crazy under the influence of that drug. We know that he acted jittery and sweated a lot when he took PCP. And we know that he was jittery and looked like he was sweating on the night of June 16, 2013, when he left in an automobile with Carlos Ortiz. And Jennifer Mercado said he looked exactly the same way when she was shown the video of Ortiz and Wallace arriving at Aaron's house around midnight that night. And there was no evidence that Wallace, or for that matter, Ortiz, were friends with Odin Lloyd. But what about Carlos Ortiz? What do we know about him? He too was a drug dealer. He too smoked PCP or angel dust. According to Jennifer Mercado, Carlos Ortiz always carried a towel. When he used PCP, he'd wipe his face with it. He used that towel to wipe his face the night of June 16, 2013, before he left in that car with Ernest Wallace. You can see in the video at the Blue Hill convenience store that Carlos Ortiz had a white towel around his neck around 2:10 a.m. on June 17th. And saw the photograph of the towel at the crime scene somewhere. Near the body. Is that a coincidence? A couple of days later, you remember, in the backyard at the Singleton's house, you heard the testimony of Reverend Irene Singleton. Ortiz was there. He appeared jittery and under the influence of drugs. She asked him to leave. Who was Ortiz with that day? He was with Ernest Wallace. She asked him to leave too. I ask you to focus carefully on what you know about Wallace and Ortiz, including their use of PCP. Did one of them murder Odin Lloyd without Aaron's having anything to do with it? Was it the result of a sudden, unpredictable, violent outburst by someone under the influence of PCP? The prosecution has presented you with a theory, a possible scenario, but it's not the only one. Has there been proof beyond a reasonable doubt that Ortiz or Wallace shot Odin Lloyd? Of course not. But it's their burden to prove their case beyond a reasonable doubt. Have they done that? No. They want you to fill in the blanks. Let's look at their scenario. Let's look at their scenario carefully. The scenario they set out in their opening statement, and see if it makes any sense. The prosecutor told you that Aaron was unhappy with Odin on Saturday, June 15th, and that he then orchestrated Odin's murder. That's their theory about what happened. In order to evaluate and examine that theory, you have to start with what happened on Friday night, June 14th, that weekend. On Friday night, Aaron picked Odin up in a rental car and they went out together to Rumor nightclub. You saw some video of the nightclub and people scattering around outside at closing time. And then you heard from Jennifer Fortier about what happened next. She spotted Aaron behind the wheel of the Suburban. She went over to say hi, along with her friend Amanda DeVito. Aaron invited the two women to get in. They got in. Aaron then, and then Odin Lloyd was in the car, along with another man too. And Aaron drove back to North Attleboro. And eventually, well, on the way to North Attleboro, this 40-year told you, there was music. The men were singing along. They were passing a marijuana cigarette back and forth. Everyone was in good spirits. There was no conflict, no argument. She described them to you as acting like little boys. Eventually, Aaron and Odin and Jennifer and Amanda went to Aaron's rented apartment in Franklin, and there they hung out for a while. There was some wine, there was some more marijuana. Aaron and Jennifer ended up in a bedroom, while Odin and Amanda were on a couch in the living room. Aaron made a pass at Jennifer, which she rebuffed in the bedroom, and he immediately backed off. The two men fell asleep. Jennifer and Amanda called a car service and got a ride back to Boston. There was absolutely nothing about that night which suggested that Aaron had any negative feelings at all toward Odin Lloyd, let alone a reason to murder him. Just the opposite. They were out drinking, smoking marijuana, listening to music, and chasing women together. Curiously, the prosecution never called either of the other two people who were in the car that night. Apparently, they considered 131 other witnesses more important. Why do you think that is? Why do you think they weren't called by the prosecution? So let's move to Saturday, June 15th. Saturday morning, after he woke up, Aaron texted Cheyenne. And I showed you that text message. Of course, it's up to you what to make of that text message. Don't let me interpret it for you. But you see the words. He's sorry. He messed up. Odin took care of him. He's coming home. He's supposed to have breakfast out with his mother, Cheyenne, and their baby. Is there anything in that text that suggests that Aaron is angry with Odin, that he, wants to hurt Odin or murder Odin? Just the opposite. And this is important. That text is on Odin's phone. Odin's going to leave with that text. This was not some secret anti-Odin message. Does the prosecution expect you to believe otherwise? But what happened after that? They drove to Aaron and Odin, drove back to Aaron's house. Aaron loaned Odin the Suburban, told him to bring it back when he was done. It seems friendly. Aaron went out to breakfast, spent the day with Cheyenne and AVL. Odin returned to Boston, where he spent the day driving around with friends in the Suburban. After Odin's football game that night, he went to a party in Cambridge, and then Odin, Akil, and some other people went to an after-hours party after 2 a.m. in the Grove Hall section of Boston. Contrary to the prosecution's claim, there is absolutely no evidence of any kind suggesting the existence of any plan to murder Odin Lloyd, or any conceivable reason why such a plan would exist. So that brings us to Sunday, June 16th, Father's Day. Aaron, Cheyenne, and AVL went on a picnic. Odin and his friends went to various social gatherings in the Suburban. Later on, Aaron texted Odin about going out together again later that night and grabbing some marijuana blunts that Odin was making. Contrary to what the prosecution may suggest, there was nothing in those texts about going to a club. No one said anything about it going to a club. Odin responded affirmatively. That evening, Aaron and Cheyenne go to the South Street Cafe, hang out with some friends. Cheyenne said they were both very intoxicated by the time they came home. Meanwhile, back in Boston, late that night, Sunday night, Odin hung out in the Suburban for a long time. Then he left for an hour from 1:15 a.m. to 2:15 a.m. Went somewhere, made a lot of phone calls, had a Red Bull energy drink. Wallace and Ortiz arrive at Aaron's house around midnight. And then shortly afterwards, after Aaron comes home with Cheyenne, the three of them leave. First they drive south, with Wallace driving. First they leave, they head south, then they turn around and head north, and they end up picking Odin up around 2:30 at Facebook. Now, Odin was 27 years old. He was familiar with the club scene. And he was clearly not dressed that night for going out to a club. He was going to hang with his friend Aaron. There was no trickery, no pretext. No one forced Odin to get into the car. We know they drove back to North Attleboro, just on Friday night. And we know they ended up at Corliss Landing, less than a mile from Aaron's home. And we know that Odin Lloyd was shot and killed there around 3:30 in the morning. All the shots were fired from the same gun, fired by whoever killed him. Now, the prosecution claims that the shooting of Odin Lloyd was the culmination of a diabolical plan, hatched, orchestrated, and carried out by our client, Aaron Hernandez. Aside from the total absence of any proof to support that theory, and the total absence of any reason Aaron would have to kill his friend, Odin Lloyd, here are four critical questions the prosecution hasn't answered during the trial, which demonstrate that the theory makes no sense, and that they haven't proven their case beyond a reasonable doubt. First, if Aaron planned in advance to murder Odin, why would he do so in his own town, where Odin didn't know anybody else, in an open location less than a mile from his own home? If Aaron had planned in advance to murder Odin, why would he leave keys to a car that he had rented in Odin's pocket, along with Odin's cell phone and wallet? And for that matter, why did Odin still have a cell phone that he was continuing to use to text with while he was in the car? Third, if Aaron had planned in advance to murder Odin Lloyd, why would he bring along two witnesses, including one, Carlos Ortiz, who had never been at his house before? And if Aaron had planned in advance to murder Odin Lloyd, why was a blunt found at the scene? A blunt shared by none other than Aaron Hernandez and Odin Lloyd, two friends who shared an interest in marijuana. If the prosecution cannot answer those critical questions, then you must be left, I submit, with a reasonable doubt. Isn't it far more likely that what happened at Corliss Landing, whatever happened at Corliss Landing, was totally unplanned, and that whoever shot Odin Lloyd did so as the result of something that arose on the spur of the moment, something sudden, irrational, unpredictable, as a result of some carefully orchestrated, premeditated plan set in motion by Aaron Hernandez? Now, the prosecution also conveniently ignores the substantial evidence of Aaron's innocence. I'm going to talk about the home surveillance video in a couple of minutes, but let me point out right now, Aaron knew how to turn that system off. He knew how to pull out plugs. He didn't turn the system off. He didn't destroy or erase or remove the hard drive when he was home on Monday and Tuesday. It was still sitting there intact when the police seized it on the evening of Tuesday, June 18th. He had nothing to hide. When the police came to his house on Monday night Aaron volunteered. He had been up Odin's Way yesterday. He consented to a police search of the Suburban. He provided a DNA sample voluntarily. He told a number of people who asked him that he was innocent. And unlike Ernest Wallace, who took off for Florida, Aaron didn't flee. That's some of the evidence that you should take into account in deciding whether the prosecution has met its burden of proof. Now, let me turn to the contents of the home video hard drive, which the police seized on June 18th. You heard testimony that the investigators looked at the original in the van. They weren't supposed to, but they did. And when Trooper Conrad looked at that original, he said he didn't notice any jumps or skips or freezes. There was no right block software in that van to prevent any changes happening on that hard drive. Compare that to what you see in the courtroom over and over. Skips, jumps, freezes. You were never shown the original. Why not? So what do you make of the version that you were shown? Mr. Reset never checked the original. He said the first clone copy, there was some data erased. They made a second clone copy. Wasn't ever hashed against the original. Is it authentic? Is it reliable? Can you use it? How can we be sure? The Commonwealth wants you to fixate on a photograph that shows Aaron Hernandez at the top of the basement stairs holding what may be a gun. I expect the prosecutor is going to show you that photograph over and over again in a few minutes. But before we get to that photograph, what's critical is to consider the context, the sequence of events preceding that photograph. I'm going to show you that exhibit 431, in just a minute. Please watch it carefully, focusing on the sequence of events. You're going to see the car pull up, the three men get out. Notice what Aaron is holding in his hand as he walks into the house. Notice what he's holding in his hand when he walks into the kitchen, into the foyer. I'm not going to tell you what it is, but you can decide if it looks like an iPad. Then you see the three men, you'll see Wallace and Ortiz head down to the basement. Aaron heads upstairs. After a minute, he heads downstairs. See what he's holding in his hand then. See if it appears to be an iPad. Not a gun, an iPad. Then he goes downstairs. Aaron disappears into the basement. It's only after he emerges from the basement, after 5 minutes or so, that he's holding what may look to you like a gun. So let's play the video now, please, if we could, Mr. Rankin. All right, so we're getting out of the car. It's about 5 minutes. skips and some jumps. There go Wallace and Ortiz down to the basement, and Aaron upstairs. See what Aaron is holding when he comes downstairs, and when he was going upstairs. And Aaron's about to come back. There he is, down the stairs. What's he holding in his hand? He goes to the basement. There he goes. Downstairs for about a minute, and then he's going to emerge. Okay. That's about it. So when he emerges, he's holding something. Is it a gun? It may be a gun. Has the Commonwealth proved to you beyond a reasonable doubt that's what it is? Mr. Aspinwall, remember him, guy from Glock, said in his opinion, it's a gun, a Glock pistol. He couldn't tell you what caliber. He couldn't tell you whether it was a real gun. He said it was dangerous to hold a real gun by the muzzle. What else do we know about Mr. Aspinwall? He's a law enforcement officer. He's been a Glock sales representative for less than 2 years. He's not an expert in firearms identification. He's not an expert in deciphering grainy video. He says he relied on the curve of the backstrap to tell you what he saw in that video. But then he agreed that the curve of the backstrap on an $11 pellet gun looked like a Glock. His agenda was to help the prosecution. He changed his opinion after December of 2014. They hired a Glock salesman to look at something, and lo and behold, he saw a Glock. Talk about confirmation bias. And what else happened with respect to Mr. Aspinwall? You'll recall that Judge Garsh struck 3 of the 4 bases for his opinion and instructed you to disregard that testimony. That's hard to do, to hear something and then be told you have to disregard it. But that's your duty. So you have to do it. So what's left? Enough to satisfy the Commonwealth's burden of proof beyond a reasonable doubt? Well, suppose you find it is a gun. How does that prove that Aaron Hernandez murdered Odin Lloyd? There's no evidence that it's the murder weapon. Let's go back to the sequence. If Aaron has an iPad, not a gun, when he walks into the house, that's important. If he has an iPad, not a gun, when he goes upstairs and downstairs, that's important. Then he goes into the basement. Who's in the basement? Wallace and Ortiz. Even if he has a gun when he comes out of the basement, what does that signify? Did he arm himself to protect himself after what he just saw happen at Corliss Landing? Did he take the gun away, the murder weapon away from Wallace or Ortiz so that no one else would get hurt? Those are possibilities. They haven't been proven beyond a reasonable doubt, but neither has the government's theory. They have a theory. They have a story. They haven't proven it. The only way to get there is by guesswork, by speculation. by using your imagination. That's not proof beyond a reasonable doubt. Let me show one other piece of video, if I may. This is a short one. And before we do it, let me just tell you what it is. This is earlier. This is just before 1 a.m. on June 17th. Just before Aaron, Wallace, and Ortiz leave to pick up Odin Lloyd. And we're going to play this frame by frame. It's very short, only a few seconds, frame by frame, as Aaron emerges from the basement. When the basement door opens, you can't really tell, I submit, what he has in his hand. Could it be a gun? Can't tell. But within a few steps, you can tell what he has in his hand. And I submit it's not a gun. So let's look at it. This is 12:56, 52 to 12:56, 56. Just 4 seconds. We're going to look at it frame by frame so you can really see it.
Once you get to 52, just put it absolutely. Is that in
See if you can tell what he has in his hand now. Now keep watching. Could be anything. And now what is it? Okay, thank you. The reason I showed you that is because it shows you how difficult it is to draw conclusions by looking at this grainy video from different angles. You can see what you want to see. Beware of seeing what you hope or expect. You think you see, whether or not it's actually there. That's confirmation bias. You need proof beyond a reasonable doubt. Now, since the prosecution can't prove its claim that Aaron shot Odin Lloyd, or that he participated in that crime, it spent a lot of time at this trial focusing on what Aaron did afterwards. Please keep in mind that Aaron is not on trial for what he did afterwards. He's on trial for murder. So what did he do afterwards? Well, he provided Wallace with a rental car. He provided Wallace through Cheyenne with $500. What else did he do? Well, he asked Cheyenne to throw away a box that was in the basement, a heavy box, with other boxes inside. She estimated 25 pounds, 30 pounds, 40 pounds, somewhere in that range. So she did so. The prosecution's theory is that the murder weapon was inside that box. But there's absolutely no proof of that. And in fact, the evidence points in a very different direction. Keep in mind that Aaron Hernandez smoked a lot of marijuana. All the time. You heard testimony that when the police searched his house, they found a scale with marijuana residue inside the house. They didn't find any marijuana. The maids had remembered seeing a large quantity of marijuana in the basement. So where did it go? Cheyenne testified that the box she removed from the house smelled like marijuana. So that's what she thought was in there. Doesn't that make sense? It was heavy, but it could have been compressed marijuana. You heard about that during the trial. Surely that bag that Cheyenne was struggling with on that video weighed a lot more than what a Glock weighs, about 2 pounds. Is it possible that that murder weapon was inside that bag that Cheyenne took out that day? Of course it's possible. Of course it's possible. Anything is possible. But a murder charge, a murder conviction can't be based on possibilities, on guesswork, on speculation. That's not good enough. Moreover, if the prosecution really believed that the murder weapon was inside that bag that Cheyenne tossed in a dumpster, why did they send scuba divers into lakes in Connecticut and in Florida near Ernest Wallace's relative's house looking for a .45 caliber handgun? That would have been pointless. Their own investigation contradicts their claim. So what are you to make of Aaron's conduct after the killing of O'Donoghue? Did he make all the right decisions? No. Did he make all the right choices? No. He was a 23-year-old kid who had witnessed something. A shocking killing committed by somebody he knew. He really didn't know what to do. So he just put one foot in front of the other. Keep in mind, he's not charged with being an accessory after the fact. You couldn't find him guilty of that charge even if you wanted to. They didn't charge him with that. He's charged with murder, and that he did not do. Now, almost done. Talking a long time. Been very patient with me. Let me say that after 9 weeks of evidence, the prosecution still hasn't proven to you. They still haven't proven to you who shot Odin Lloyd or why. Was it Ernest Wallace? Was it Carlos Ortiz? Was it Aaron Hernandez? Did it or with another? Did they all do it together? The prosecution has accused Aaron of orchestrating a murder. But where's the proof? Where's the proof? It isn't there. They want you to speculate. They want you to apply a presumption of guilt. They want you to fill in all the gaps. They want you to guess. They want you to use your imagination. That's not the American system of justice. There has to be proof. Proof beyond a reasonable doubt. To a moral certainty. You don't have that in this case. Not even close. Now, I expect the prosecution is going to get up here and they're going to say, well, we don't have to prove motive. And they're right. They don't have to prove motive. But if there's no motive, if there's no reason, if there's no earthly reason why Aaron Hernandez would want to murder Odin Lloyd, then their theory doesn't make any sense. The prosecutor may also get up here in closing argument and say, we don't have to prove that Aaron Hernandez fired the fatal shots because this is a joint venture case. And he's right. They don't have to prove that Aaron, but they still have to prove that he actively participated in the crime and that he did so with the required criminal intent. There's no proof of that here. There's no proof he orchestrated a plan to murder Odin Lloyd. There's no proof he participated in a joint venture to do so, so he can't be convicted on that theory either. Please keep in mind what isn't enough to convict him, to convict Aaron of murder. Even if you find he was present, that's not enough. Even if you find he associated with the perpetrators, that's not enough. Even if you find that he knew it was going to happen, that's not enough. Even if you find he didn't do anything to stop it, that's not enough. Even if you find he may have been involved, that's not enough. Even if you find he was probably involved, that's not enough. Even if you find there's a strong likelihood that he was involved, that's not enough. even if you find he helped cover it up or assisted the perpetrator afterwards, that's not enough. It's hard to convict someone of murder in our system of justice. It's supposed to be hard. It's supposed to be hard. That's what the founders of our nation intended, because the consequences of a mistake are just too grave. So there has to be proof beyond a reasonable doubt. It's a heavy burden, a heavy burden. In this case, the prosecution hasn't come close to meeting that burden, not even close.
Your 5 minutes, Reverend.
Thank you, Ron. Well, I ask you, each of you, to just follow Judge Garcia's instructions, and you'll reach the right result. Each of you has something important to contribute in deliberations. There's no professional jurors here. Each of you should contribute. Don't be shy. Participate. Speak up. Well, less than 5 minutes, I'm going to sit down. The prosecutor's going to get his chance to address you. That's how it works. And I haven't discussed every single piece of evidence and every single exhibit and every single witness. And if there's something that you think that I neglected to mention that I should have, please don't hold it against Aaron. But if someone says during deliberations, why didn't the defense explain this? Why didn't the defense explain that? I hope you'll respond, you've got it backwards. The defense doesn't have to explain anything or prove anything. The question is whether the prosecution has proven its charges and whether it's done so beyond a reasonable doubt. No matter how many times during his closing the prosecutor points his finger at Aaron or tries to tell you what you're seeing on a video or tries to do a recreation of the crime, it won't make up for the lack over the past 9 weeks. The absence of proof beyond a reasonable doubt. You decide this case, not the lawyers. Why would Aaron risk a successful and lucrative career and a promising future to murder his friend? Where's the proof he intended to do so? What proof is there of an orchestrated plan? What proof is there that Aaron did of what Aaron did at Corliss Landing? What proof is there that he fired the shots? What proof is there that if someone else fired the shots, that he actively participated? Why didn't they obtain Ernest Wallace's DNA? Why didn't they test the bubble gum? Why didn't they call Trooper Benson to defend the investigation? Listen to whether you get satisfactory answers to those questions during the prosecutor's closing. Members of the jury, if you ever visit Washington, D.C., and go to the Supreme Court, you'll see 4 words right at the front. Equal justice under law. Aaron Hernandez does not deserve any special treatment. He doesn't want any special treatment. None. Don't give him any. Don't give him any. Give him the same consideration, no better and no worse, than you would want to give to any citizen of your community charged with this most serious of crimes. Ladies and gentlemen, this is a terrible case. It's about the death, the tragic death, the violent murder of a young man, Odin Lloyd, and about another young man, an innocent man, charged with that murder. Don't compound that tragedy. Don't compound the tragedy by convicting an innocent man. Don't make a mistake. Your decision is final. I ask you, I implore you, based on the evidence and based on the lack of evidence, to find Aaron Hernandez not guilty of the murder of Odin Lloyd. Thank you very much.
I expect that the prosecutor's closing will also take about 90 minutes. I do not want to take any recess or interrupt during the closing. So if you any of you think that you're going to need a very short 5-minute break before we go to the prosecutor's closing, if you could just raise your hand and we'll take a short break now. Then we'll take a short recess now. Please, you've not heard the prosecutor's closing, you haven't heard the court's instructions, you're on the law, so please keep an open mind and do not start discussing the case at all among yourselves or with anyone else. 5 minutes.
All right. Sure, please.